most importantly, what my students and I do is we try to represent renegade creators who are trying to do ventures that the law hasn't anticipated. It's a very interesting place to be. It's particularly scary for young lawyers who just want to know what the law is. And for me, I keep telling them this is a great place to be, a great time place to be a young lawyer, because you're going to be inventing the law as you progress in your career. And it's particularly true in the case of wearable tech. I got to say, this, when Paul asked me to speak on this panel, I was intimidated. I said, I don't know the first thing about IP issues surrounding Fashiontech. And then I thought for a minute, you know what? No one does. It's completely untouched terrain, and those of us who are playing in this space are the pioneers, and we will shape the laws and policies that will govern this space for decades to come, which is a pretty impressive place for us to be. I first learned about wearable tech about 7 years ago. 7 years ago, I think, yeah. And it was in this very room. I didn't know what the hell wearable tech was, but Eyebeam, who knows Eyebeam? A bunch of you know Eyebeam because she was a fellow here, and then she was a senior fellow here, and then she launched a company called Little Bits, and she just got many, many millions of dollars to open up retail spaces for Little Bits. If you don't know what Little Bits is, it's essentially open source electronic Legos that allows you to build whatever you want electronically. It's really sensational stuff. But I was here, and she shows me, she showed me her undergarments. She had long underwear, and it was really the first moment I saw the capabilities of wearable tech. It was underwear that you wear when you go through detectors at the airport. And it records and photographs and monitors the activities of the TSA surveillance folks and their treatment of you. So it's basically surveillance on the surveillors. And that was the first, so my first exposure to wearable tech was a very positive one. This was going to allow citizens to watch government, citizens to watch corporations. Now it's changed over the past 8 years, and maybe we'll get into some of the privacy aspects, perhaps. We probably stick mostly to the IP issues. But in any case, that was my first exposure, so I'm thrilled to be back. I think I know a little bit more than I knew 7 years ago. I called my little presentation, I don't know if I'll actually get to it because I think I'm going to get caught off in a minute. I called it The Blind Leading the Clothed. It's an homage to a little nod to the Violent Femmes. Any fans of the Violent Femmes out there? All right. And around 1990, they put out an album called The Blind Leading the Naked. And I didn't know what it meant really, but I do know what it means here. What it means in this context is me as an attorney, Nigel as an attorney, these folks as art authorities, we're largely, at best, the one-eyed person in the world of the blind, but we really don't know what the future holds. And we are here as sort of guides to work with you all, the clothed, as we try to work our way through the morass of legal and technological issues. I also mentioned that I teach at, I'm a visiting professor at the University of London. So I think that's something we may want to touch on is international corollaries, because a lot of what we think is legitimate in America is not legitimate in Europe, particularly when it comes to privacy issues. They have a much stronger privacy approach than America does, although it's kind of the opposite of America. So in America, I always think this is ironic. Americans seem very willing to
have 1 minute left.
Crap, I got my first slide. That's fine, because I can talk about it in context. I just want to say, Americans in the privacy context are very willing to give over all their information to corporate entities. Google, Facebook, we're just starting to get a little bit skittish about it, but we are skittish about giving over any information to the government. That's where we draw the line, which is why it was absurd, I thought 3 weeks ago when Obama said, well, we're not going to be keeping all your data anymore. We're going to outsource it to Verizon or Google, outsource it to private enterprise. Is that a good thing? At least we have constitutional protections when it's the government that has access to our information and not, by the way, I'm a hypocrite. I am wearing my Nike Fuel Band. So not only am I not getting any they don't get my biometric information, but what they do, I want Nike to love me. Some corporate stranger to love me and make sure I hit my numbers all the time. This is my first real exposure to wearable tech. I think that's all I should say at the moment. I got through none of my slides. Someday, perhaps I will. Okay.
So I'm Nigel Howard. Very nice to meet you all. I'm also a lawyer, like Jonathan, but I work in private practice. So I represent both big companies and small companies, startups. I had the choice at 18 of going to either art school or going away to university, and I ended up studying law. I always thought, well, I wonder what would happen if I'd taken that other path. I've always had a great love of the arts. And my practice focuses on really three areas: intellectual property, technology, and data, and including the data is the privacy issues. And I'm a transactional lawyer, so I do deals that revolve around those assets. And on the slide here, you can see some examples of some of the clients that my firm represents. I work at a firm called Covington and Burling. It's around 800 lawyers with offices around the world. And we represent both technology companies, such as Microsoft and Samsung and Facebook, but I also represent fashion houses and clothing companies. I've been lucky to do work both for Microsoft and Patagonia. Love Patagonia, love Microsoft too. But, and it's very interesting for me now seeing these two worlds kind of colliding more and more. And I've just always loved great design, and the intersection of the two worlds is just really fascinating. I've also put on the slide two other clients I represent, American Airlines and British Airways, and you probably wouldn't think necessarily that they would even be relevant for this discussion. But in fact, some of the first wearable tech questions I've come across for some of my clients have actually been for airlines, thinking about how flight attendants, for instance, could use wearable tech, in particular things like Google's Glass. And then the last couple of companies mentioned on the slide are examples of work I've done for early stage companies I'm particularly proud of. I represented DoubleClick before it went public and was their main technology lawyer for about 6 years. Had a lot of fun writing some of the first ad serving contracts ever written, coming up with internet affiliate programs before they had really ever been developed. TouchTunes is another actually Canadian company, but with a large New York presence, digital jukes boxes. They're just some of the examples of some of the early stage companies that we represent and help build.
I work in a very ethical field, and my main job is to ensure the preservation of the art that we both collect and that we borrow and put on exhibition. And you might think, why am I here? What am I doing? I'm definitely not a lawyer. And when I first talked to Sabine, it was like, oh gosh, what do I know about IP? But you'd be surprised that issues dealing with IP do actually enter my kind of daily sphere. So the main question is, how can I preserve this? How can I protect this artwork? And if it's damaged or decaying, or if it exhibits something that we call inherent vice, which is a wonderful term which describes a characteristic inherent into in the garment or the object that is contributing to its decay. How do I stop that? You might think technological fashion is a new concept, or at least from the 70s or 80s, but as you can see from this dress in our collection from the 1920s by Patou, it's been around for almost a century. And this dress that you see behind me is called advertising. It's kind of a double entendre. Both the light at the top of the Eiffel Tower lights up. If you go to the next slide, these are actually the components that are in this dress. So it's advertising for the Eiffel Tower and for Paris, but maybe it's advertising for the woman, you know. She's kind of showing off. So when I encounter an object like this, you know, I'm charged with preserving it, and I don't have any of the plans that included. You know, I don't know exactly how it goes together. I'm not an engineer, so of course that means I have to consult with people working today. Fast forward, we've got this other piece in our collection that came from the Brooklyn Museum collection when we acquired it. Here we have this suit called the Action Suit, which I don't know if you can see, but includes a mini vacuum cleaner, a little rotisserie, you know, everything a woman needs for, you know, action. And this suit was actually created in the early 60s, but it was meant to envision what fashion would be and needed to be in 1970. So, you know, I do have some exciting kind of almost analog components, you know, computational fashion in the sense of technology merging with fashion. Now, a few years ago, we just acquired this piece here, and I'm sure if you know anything about 3D printed fashion, you would know what this is. This is Iris van Herpen and her famed skeleton dress. When we collected this was a whole nother basket that, you know, I just sat and I looked at it, and if you look at it, I mean, this is a frightening piece. It's incredibly fragile, and this is the only one that exists. So this kind of got me started, talking with the curator and other people in my department, and we said, well, okay, can we collect the code? Is the code the object? Is this the object? Next slide, which leads to issues of authenticity and ethics. I am ethically bound to protect and preserve this piece. If, not saying it would, but if something were to happen to it and we had to replace a component, what is the more ethical path that we choose? Do we handcraft something? Do I somehow get the code and then be able to print a replacement part? It led to all of these questions. And so my last slide, which kind of brought me to this area of, also discussing with our digital media department and the designer herself. These are questions that I've started, including whenever we are looking now into collecting 3D fashion. Collecting the code, who owns the copyright, who's allowed to print, am I allowed to print should anything happen? If I do print, could I even print? Do I have a printer that would work? What is the resolution? What is the base material? All of these questions are things that if you are going to be, giving a piece to a museum or to a collector, or if you're looking to collect these pieces, then you might want to take this into consideration. So I'll stop there, but as you can see, I do have something to say.
Absolutely. We curate the world of entrepreneurs for interesting technologies that are emerging. We usually say pre-Series A, so before they raise some major sum of money, and we connect and we showcase them, connecting them with top brands. And I do that by creating events that are very, very creative and push the boundaries. We have two kinds of events. We have the large summits. So summits like this is the Milan landing page. This one here, it's going to happen in May. It's we're bringing what we did here in New York last year. It's the Fashion Hackathon. We created the world's first fashion hackathon. Condé Nast was part of it. The way I did the hackathon was different. We ended the hackathon, which is a competition, 24 hours, with 5 finalists. And then I brought those finalists to the tents. And at Mercedes-Benz Fashion Week, between Ralph Lauren and Calvin Klein, we stopped the tents for 3 hours, and we did a technology summit. It was completely out of ordinary, and everyone went, what? And then we got Zach Posen, who is the most technology-minded person you can think of, right? No, not really. To be the judge of the hackathon, because it was really about technology speaking to the designer, and not the designer feeling intimidated. It's not the designer being judged by his technology knowledge, but the technology gaining, actually capturing his imagination and being wanted. And the other side of what we do is the meetups. So the meetups are monthly events that we do all the time. The next one is this Friday. Will be also about wearable tech at the Museum of Art Design here in New York. We create environments like this in which we bring some of the best founders that are out there right now at the moment, some undiscovered, and we start the meetup with a panel of experts, and they pitch for 10 minutes what's their next great idea. One thing that we do too is the mentorship hub. We bring it to South by Southwest this year. I'm on the board of South by for the wearable tech competition, and also for anyone who wants to speak to fashion at South by. I'm on the judging board of that, and I saw the need to bring more fashion content, and the way that I'm doing that is by bringing all the mentors that I could grab, all of the heads of digital of all the brands, luxury, retail, they're there every year, and to make them available to anyone who attends, badge holders, and they'll be mentors for you. So we call this the mentorship hub. And what I want to say quickly about IP is that fashion and technology are completely different the way they see it. And it's funny, when Sabine first called me, I'm like, yeah, we are the ones. Technology, I mean, I'm 60% tech, 40% fashion. And when I think of my tech side, I'm like, yeah, no, we are the ones who really see this thing right. And then when you start digging, actually fashion has a lot to teach tech about IP and how they embrace it and how they thrive around it, around the challenges. A garment, it's not something that could be guarded with IP, the way technology, the way code is. So they have to be very inventive, they have to be very creative, and I'll talk later about what's the result of that.
Well, speaking of that, maybe Nigel, that's a very good, question, segue to you. So what's the difference actually? We're talking about patents, design patents, IP. What is IP actually? Copyright? What's all that crap?
Well, there's lots of different types of intellectual property rights, and the systems exist in each country. So there's a different system in every country you go to. So actually, it's one important thing to keep in mind, that whatever protections you might obtain in the United States don't necessarily automatically apply in other countries. There are certain international conventions between countries which do allow a certain amount of reciprocity, but one of the most important things to just immediately take on board is that when you try and protect something with intellectual property, you have to think in terms of national rights. And if you have something that's commercially important around the world, you'd have to receive the same kind of protections in each country you want to sell your product in. There's two types of patent right in the United States for that are relevant for fashion, and they're quite different types of patent. There's the design patent and the utility patent. A design patent protects new, non-obvious, non-functional ornamental items. So this is actually an example of a design patent. This is it's actually one that's been quite controversial. Lululemon. It is. Yeah, there you go. So that serves its purpose. The design of the belt on the exercise pants was something that Lululemon thought was commercially important enough that they actually applied to get a design patent. And as you can see, I guess this aspect of the design on the pant, it really is on the pants, is really just ornamental. It's to create the aesthetic of the pants rather than actually necessarily just hold the pants up. And what's very interesting about design patents is that historically they haven't been terribly important for fashion. And one of the main reasons is because fashion changes so quickly. And it takes actually quite some time to obtain a design patent, usually about 18 months. So if you spend a lot of money, take 18 months, and then the ornamental design is no longer fashionable, then you just wasted your time and money. But increasingly, because of the advent of technology, ornamental aspects of fashion and design seem to have a longer life to them. And so big companies are starting to really invest in design patents. And there was also a change in the law relatively recently, which made it a lot easier to enforce design patents against infringers. There used to be a test that you had to satisfy before you would succeed in your case to enforce the design patent, and that was rejected in 2008. And ever since then, companies have applied for more design patents. And this particular one was controversial because Calvin Klein brought out another pair of pants, much cheaper pair of pants with a similar kind of belt, and Lululemon sued them. Now, there was no final decision. It was settled out of court. But it's a good example of how design patents have become much more important in the fashion world. So there is these two types, and the second type, the utility patent, this covers new, non-obvious, useful inventions. So if a design patent is for something that's ornamental, the utility patent is for something that's useful, functional. And this is by far the largest category of patents that exist. And when you normally think of patents in the technology arena, it's the utility patent you think of. This is an example of one diagram from a wearable technology patent. This is actually from the patent for the shoe insert for the Nike shoe that can connect with the iPod for purposes of exercise. And as you can see, this shows a schematic of how the process that's the subject of the invention works. And it's describing the function of how the insert communicates with the iPod. And so what a utility patent does is give the owner the exclusive right to make, use, and sell the particular product or service or process that's the subject of the patent. And it gives a legal monopoly to the owner of the patent. as does the design patent. That also gives a legal monopoly, but it's to the particular ornamental design that's the subject of the patent. A design patent lasts for 14 years, and a utility patent lasts for 20. Somewhat confusingly, the time periods are calculated from different points. For a utility patent, it's 20 years from the date you apply, basically. For design, it's 14 years from when you get the patent. There's a whole reason for that, which I won't go into. But I think one of the things I want to leave you with about the patents, though, which is, I think, really important to take on board, is that these are legal monopolies that these rights can give you, but that doesn't mean you're actually going to have a monopoly in practice. And these rights are not inexpensive to obtain, and they're only worth pursuing if you've got something that's going to be commercially important. So to give you a kind of order of magnitude, a design patent might cost several thousands to apply for. A utility patent can easily run $10,000 to apply for. And that's just to get the application process going. To actually finish the application process will inevitably cost more money as well. And easily, a utility patent application just in the United States can cost $30,000.
I want to try a quick case study if Nigel's willing to go through this with me very quickly. And I think we have two perfect examples where we can dissect the differences between patents, copyright, and trademark, beyond just utility and design patents. And we got the Lululemon thing there and the 3D printed dress there. I think those are perfect examples of the confusion, the growing confusion between patents, trademarks, copyright, and trade secrets in a fashion context. So the Lululemon thing, when you showed that to me, I thought, well, I assume Lululemon's going to probably seek trademark, and then secondarily copyright, and third, utility patent on it. So do you know to what extent Lululemon tried to seek, did they allege any copyright violations, trade dress or trademark violations, or did they really just stick with the patent, the design patent?
The case just focused on the design. Now, it's very interesting to me because in many ways some of the tests that are examined as part of the infringement analysis for a design patent is very, very similar to trademark. And there's even overlaps with copyright because the test is there's substantial similarity, which again is obviously a copyright concept as well. So I actually don't know why they thought the design patents, and they applied for a number of different design patents, why they thought this would be a particularly effective means of protection. But it certainly, I mean, we don't know what the ultimate outcome of the case was because it was settled. But it certainly had some degree of chilling effect on what Calvin Klein was doing. So that's success in itself.
And then if I could follow up with the 3D printed dress, if you were the attorney, what would you recommend to the designer, inventor of the 3D printed dress? This, to me, can go in any number of ways. There's certainly there's trade secret issues, conceivably, if it's all code that you don't want to share. There's copyright issues, both in the code that's developed and in the actual finished sculpture.
Well, when I talk to Iris, or her team, essentially the copyright is owned by her, and the future copyrights for printing more dresses is also owned by her, and only she can do that.
Right, well, because there's two layers of copyright. There's
right.
the copyright in the code and the copyright in the fixed.
In the fixed dress.
Yeah.
Right, but
So
the Met now owns that dress, but then of course there's this whole Visual Artists' Rights Act that we're now charged for protecting it and making sure that it represents her work.
But that wouldn't apply to the code, though, would it?
No.
So, and I wonder if for the code whether fair use doctrine would be relevant. That is it?
Well, that is exactly what
Right.
when you were telling me that. So what if the code is floating out there somewhere, is not protected, and it's just reprinted because it's an additive manufacturing process that requires code, but the actual piece itself is the piece that is in the museum and not the code. So where does, in this case, Iris is holding the copyright on the actual code. However, so those are all the things that I think are going to be very interesting not only for 3D printing, but for any type of manufacturing process.
Frankly, with the code, unless it was open sourced, it's subject to copyright, at least common law copyright, even if it hasn't been federally registered.
Right. Well, just to clarify, we tried to collect it, or two of the reasons why we wanted to collect it is one, potentially in the future there might be a way where we could generate this, this object again, or a piece of the object if ever needed. The second was purely for research purposes, so that, 10 years, 50 years, 100 years in the future, we will have this information available for researchers coming. Yeah. So, we're still in discussion. We don't have the code at all. We just have the beautiful dress.
Fashion doesn't have the protection, right? So there are two things that I think about IP and fashion. First is the inspiration, right? So they use inspiration from previous designs to create new designs. There is always someone saying that someone copied someone from someone, and it's just the culture of creation between artists in fashion. And then another layer that they add to that is the aspiration. So it makes the industry to really engage in the race of the better product, and it makes the industry stronger. So they create aspirational products. So Chanel is not going to be, of course, they very worried about Chanel bags being printed out in China, right? Printed out, so 3D. One day, unfortunately. But they worried about the perception that that's their item, but the look of the item, they know they cannot hold on to it. That's the whole scheme with Forever 21, right? There are a few brands that I cannot engage with, because the moment I put them in a room, a whole number of people will not show up to my events if they're there because of this dynamic. Yeah, there's the brands that are perceived as the serial stealers of designs. So they create this brand that's really strong, this experience, and that's a lesson that tech has learned very recently, that technology should not be just a product. Software should not just be code, it should be UI. So UI is something brand new to tech. If you think about Pinterest, it's almost like the genesis of taking UI very seriously. Maybe you can make an argument that others before them created better UI, but Pinterest sent a very strong signal that design is intertwined with tech, what comes down to traction and something that stays. When it comes down to IP and Pinterest, you should know that Pinterest stole the idea from somebody else. Pinterest was, I think, the third iteration of that concept of, when I say Pinterest, you know exactly what I'm talking about, the squares, right? A new visual way to communicate data, imagery. So they just executed it more beautifully, and that made it stay. So that was their IP, right? It was made to stay. I don't think Pinterest has that trademarked or copyright or whatever it is anywhere, because they can't. There was another one that came after them, Pinterific, or something like that, and which was so fascinating because Pinterest was so caught up in iterating the product in the US market that this other one went ahead, took the same interface, the same exactly thing, and executed in all emerging markets. And they became huge in China, Brazil, Russia. And Pinterest was like 2 years later thinking, oh, how can we launch in China? And then there was this other one there that was like huge already. So that happens a lot in tech. And then what happens then, the company that did the ripoff, they already knew that their goal was never to be Pinterest. Their goal is just to be acquired by Pinterest, just to create a nuisance and a way for user acquisition. That happens all the time in tech. So it's just an M&A situation. That's how they handle IP. They just buy the other. So the other side of tech is the side of IP heavy. It's when companies sue the other, the giants. They do that all the time. They really hold on to all kinds of legal safeguards. But the small guys, the little guys, they're emerging, and there are so many of them. The mistake that they make when you mention investors, right? It's important to investors, but when they sit across a venture capital firm and they say, here's and I'm also thinking of a wearable tech company in mind when I say this. It happened last week, this story. So they sit across from this venture capitalist saying, I need you to believe in me. I need $1 million. This is the next big thing. And then the VC asks, okay, so this sounds a little non-defendable to me. How can you protect this creation? Okay, let's say is the LED, garment that you're wearing. How do you protect it? I can just put LED in a garment tomorrow. Why should I invest in your brand instead of another brand? Why is my money safe with you? And this guy answered, this founder who I love, his answer was the worst possible answer. And it's an answer that I hope you don't say to an investor, I have the patent. That's not an answer. Because just like Pinterest, it's not enough for protection. It's traction, it's much stronger than patent in technology world. So,
my students and I work with a lot of bootstrapping companies, self-funded, unfunded, minimal. So I tell them, come up with your hierarchy, figure out what the cost is for each sort of protection, figure out what you want to expose to the world, how quickly you want to get to market. So we can take them all in turn. Frankly, if you've got a patent, it's usually going to cost several tens of thousands of dollars. My students actually, I have 9 students this semester who are patent prosecutors. They do it for free, but only for unfunded or bootstrapping, very creative clients who otherwise, with some social value component also. So there are ways to sort of beg, borrow, and steal, even in the patent context. But my attitude essentially is copyright costs roughly $100 actually to register. I forget what it is now, $130. It depends on what you're copywriting. But you can get common law copyright for nothing. It doesn't allow you to sue in federal court, but for something on the order between $75 and $150, you can copyright stuff. You can copyright packets of images for something a little bit more. That will give you the right to sue. Now, if you're copywriting code, for instance, very, very often people decide, should I just keep this a trade secret and not let anyone else see my code? Or should I, in fact, copyright it and let it be there at the Copyright Office, potentially available for the world to see? The answer to that is, if you're going to do a federal registered copyright, you can put hash out the code so people can't actually see the code. Another great little trick for you if you want to claim even common law copyright protection, a lot of coders do this, almost all coders do it, map makers do this, put a little imperfection in. So if it ever becomes a battle and someone says, well, I didn't copy your code, you say, why did you do the exact same bizarre imperfection that I put into that code? You'll notice, I don't know if anyone is aware of this, almost every map has a little imperfection, a street that doesn't exist, a river that doesn't exist, a little extension, and it's there to protect the copyright and make sure that no one can get away with copywriting them, with misusing their copyright. Now, I'm frankly sort of an anti-IP lawyer. I don't even teach IP law. I'm a technology lawyer, and my objective is to pave the way for creative startups. One of the things I love about the Eyebeam community is so much of it is founded on freeware and open source. And to me, that's a beautiful thing. So we've come up with some solutions for things like, so what about the small inventor who doesn't have the resources to patent their solution? What can they do, and should they be afraid that someone else is going to actually patent their idea and beat them to the patent office? So last year on March 15th, America, through the American Invents Act, went from a first to invent to a first to file regime. That means whoever files first with the patent office can get the patent, even if someone else sort of invented it beforehand. We've got a website now called firsttodisclose.org that allows people who may not really love the idea of patenting things, they might want ideas to be exposed to the world, or they don't have the resources to file the patent. They can post to something, there are other sites like this too, but something like First to Disclose, you would post your idea, post your patent, expose it to the world. So now it exists on a site. Arguably, no one else can go to the patent office and file the same patent, because now you've got some prior art. But it arguably also gives you a 1-year lead time, at least in America, if not in Europe, to go to the patent office. You have a 1-year grace period between the time you expose your idea, your invention, and the time you actually have to file your patent application. So I think that's a nice little trick for an unfunded or bootstrapping company that doesn't want to throw all that money into the patent regime. So patent's tough. It's tricky if you have to pay for it. Trademark, I'm dubious about suggesting that early stage startups trademark immediately. You get a common law trademark just by mere virtue of using your mark in commerce. That's pretty good. Again, you can't sue in federal court. You have some right to sue in state court. But my attitude is, if you don't have the money, why even spend the $325 plus attorney's fees to file the trademark? If you have it, it's money well spent, I guess, but it's not the first thing I would do. before lining up your, the first thing I would do is incorporate and do your IP invention assignment agreements between everyone that's connected to you and, get them all to sign NDAs. That's the first good use of your legal resources.
There's a lot of things and 3D printers coming out with, you could just put a bracelet in somewhere, scan it, and then you can print it. So when you're talking about IP and things like that, I guess by the time it would go to court, maybe it's already sold and it's sold out, and then maybe trying to find that company online. What are your thoughts about that and trying to protect that? I guess if you look at it from like a fast fashion model, what do you do then?
Well, we've seen the rumblings already. We had there was something that MakerBot had launched connected with MakerBot called Thingiverse.
Yeah, that's what I'm thinking.
Where people would put their ideas up and other people would steal their ideas and they would get sued for copyright infringement. So, I mean, I think this is a fascinating place for fashion designers, technologists, and for lawyers to live in this space. There's going to be work for everyone fighting these battles, and I think the law is so uncertain. Now, my advice generally is, in a world where the law is suspect, the law doesn't exist. So my attitude is be as courageous as possible. As I'll give you an example of as a young lawyer, I represented a company called Free World Dial-Up. Has anyone heard of Free World Dial-Up? I bet no one here has heard of Free World Dial-Up. Has anyone heard of a company called Skype? Interesting. Free World Dial-Up was Skype before Skype was Skype. Every analyst talked about Free World Dial-Up as this great revolution in peer-to-peer communications using the open internet. But they had an idiot for a lawyer. They had me. And I said, wait a second, this is a very interesting product. Let's make sure we get the proper regulatory authority, make sure we're not going to be regulated telecom carriers. So we submitted a petition to the Federal Communications Commission. Took in lightning speed, a year and a half or something, the FCC rules that our service is not a telecom service subject to regulation. Meanwhile, these renegade artists, guys who had done Kazaa, weren't allowed in America, didn't give a damn about US law, were functioning overseas, and they had a year and a half lead time and built Skype, which was exactly Free World Dial-Up with a larger consumer base. I give all credit to Skype for having succeeded in a way that Free World Dial-Up didn't. So I would say be courageous when the law is uncertain. And I don't know if that may not be the Covington model.
I just wanted to ask the same question, exactly.
We represent a number of companies in their enforcement actions for counterfeit goods. For instance, we represented the Microsoft and the Business Software Alliance in relation to their enforcement activities around the world. We actually have a unit within our firm that has built technology that crawls the web looking for counterfeit activities. And so the kind of enforcement world will adapt to frankly, we've been thinking about, what does 3D printing really mean? Ultimately, big companies are rational too. People making a one-off or creative people. I mean, the whole of creativity and like a lot of Larry Lessig's writing about how all creativity builds on one another. And big companies aren't immune to those same philosophies as well. But it's when it gets to a stage where you're starting to take the commercial opportunities away from the company that's invested in building the intellectual property in the first place, that then it starts to become a problem. So if, in your example, you're manufacturing thousands of the same bracelet, then you should start to be worried.
But I think fashion is in a fortunate position in that most of these battles have already been fought ahead of time in the context of music and video. So learn from their lessons. I do think there's something to be said to try to be, if our goal is to be fashion forward, to be the trick is to be transformative, to mash up ideas, to try to hope that you are maybe all genius rides on the back of the shoulders of genius that preceded it, and but we do have the emerging problems of taking something and just replicating it. I assume the people in this room are probably more in the transformative art side of that equation, though.
We're starting to actually 3D scan a lot of our objects for, again, digital documentation, research purposes, and perhaps putting on the website, creating animations, et cetera. But I mean, this skeleton dress lends itself perfectly to 3D scanning, and then we have that file. What are my rights? do we have?
This is the legal third rail. This is
Right.
I'll tell you this. My students and I have a client that has there are 3 of these in the world. It's a full body 3D scanner. Now you've probably seen the Kinect devices that don't really work that well, and you got to have to stand perfectly still. These devices have essentially 60 ultra high definition cameras. You walk in, it's like the next generation photo booth, MRI/MRI machine, and it creates a perfect replica of yourself. Now, who owns the CAD file on you?
Right.
I mean, the moral, ethical, legal implications are bizarre there. Now all of a sudden, you know, if you're 12 years old, 12-year-old girl goes into a 3D scanner, and the CAD file is owned by the company. What nefarious activities can they do if they claim IP rights? And you're probably signing away, you're releasing IP rights to the company that owns the CAD file. And they can make multiple replicas of you. So I think there probably is an important policy battle to say that you have the you have rights in your own autonomy and likeness. But this would require probably a change in the DMCA, the Digital Millennium Copyright Act.
People get so excited about the printers, and they forget that printers are 20 years old. And when I see 3D printing, I think of aircraft and medical. You know, I don't think of that dress. What makes me think about that dress is materials, and how the materials are the exciting part of 3D printing, and how that sounds cool to you, but the metals is so much more exciting, and where it's going from there. That's where my mind is right now. So to speak to your point, I didn't want to bring singularity into this, but I worked in this weird project in Moscow about printing human organs. And don't even get me started, but this is getting really real, really fast. And when we're talking about bioprinting, then what do we do?
I wanted to ask about how open source hardware can be applied to fashion, or where you see the overlap of like, okay, so this thing I have copyright over, I want to share it with you, and here's the license I've applied to it so that you can share it. I can share it with you in the way I want to share it with you. How do you see that application to the copyright layers in fashion, maybe as the worlds are merging more? How can you see open source? With you,
do you mean the consumer, or do you mean like a brand, a possible partner?
How will open source hardware influence fashion? Is my question.
I'm going to share a case study. Maybe it would be great to see what you guys think of it. So there is a project that I'm working on right now. It's a couple that came up with a concept. It's a wearable tech concept. And they wanted to present to a fashion designer. So I introduced them. And it's one of those things that they don't have a patent on it. It's such a great idea. No one has thought of it. They thought of it first. They can go to market without a partner. They're going to have this partner meeting. They can steal the idea. So what do we do? So they talking to this fashion designer. They developing the product together. They're going to launch it in the fall. And here's my advice to you. I think you need to decide one thing. Are you the one going to market with it, or do you need a partner? Do you need a vehicle for that? If you're just the hardware creator, if you don't have a vision, if you're not the company, in a B2C kind of way, I think you need to really take a deep breath and protect yourself and file a patent, get legal advice, and go very carefully. When you take these meetings with designers, and now the designers are getting more and more tech savvy, they have tech teams, and they're starting to behave a little more like Burberry and Apple. And when you take meetings with them, you better know your shit, because they're going to run with it. All right? If they feel that they have a meeting with someone that cannot deliver, they're going to say, great idea, I don't think I'm going to partner with them, so who can build this for me? And that's the way they operate. So there are meetings that you take. I'm not saying Burberry steals ideas. I'm saying that Burberry has the power of execution. So if you're going to bring an idea to the table for Burberry, you better know how to execute and prove it, so they see value in you as a partner. Just don't throw your idea around. So be careful who you expose your idea to, and be now, if you are the company, the competitor of this concept, they actually the company, she just went to market with it. She has a vision for it. She's gaining loads of traction in the consumer side. And we believe in tech, this lean startup machine kind of way to do things. If you build this community around you, if you build a brand, it creates a protection around you. One thing that I want to just throw out there is that I hear that a lot about 3D printing, mass production. Don't jump to that conclusion. 3D printing, it's not mass production. I don't know if you've seen something being printed. They're not taking jobs away. They're just creating different kinds of jobs. It takes a shitload of people to print something. You create the CAD, you upload it, you have the software developed, and then you have this huge printer, don't be distracted by MakerBots. MakerBots is not mass production, right? And then you have the person who takes the thing out of the powder, polishes it up, and then something else has to be done to it, the finishing, the polishing. So it takes a lot of people. 3D printing is luxury. It's a luxury plate, something very special. It's one of a kind. And it's expensive. And I think that it's going to get better and faster, but I think that element of 3D printing is not going to change for many, many, many years.
And my final is a question to you all. How many of you have ever had a need to consult a lawyer? How many of you have never had a need to consult a lawyer? All right, so almost all of you had a need to consult a lawyer. Now, those of you who had the need to consult a lawyer, were you scared, reluctant? Was it sort of the last resort? Oh my God, I got to speak to a lawyer and they're going to tell me I can't do this and they're going to screw up everything I was planning to do. Is that the general MO? Does anyone disagree with that? You disagree? Good. All right, that's good. I think that what used to be everyone's general conception of the lawyer, they're at best a necessary evil. Their objective is to either help you when you're in trouble or troubleshoot beforehand. My hope now is that with this complex area, you're going to have the lawyers up front, but they're not going to be so much what I call yeah, but lawyers. They're going to be why not lawyers. They're going to be enablers. They're going to be your partners, the people who are going to guide you through the morass of legal confusions and jurisdictional confusions. That's what I sort of hope you can take away from this, that if you can get the lawyers in early, but get them not to stifle your innovation, but give you reasonable guidance, you're going to be better off, at least if you know early on, with the right sort of lawyer that's not going to stifle innovation on your part. I think that's sort of my final word, especially in this area that is so confused and uncertain.
Thank you. Absolutely. Nigel, can you top that?
That was great. I think what Jonathan said is right. The lawyers really can and do play an important role in facilitating things happen. That's the reason why I did litigation at the start of my career. You basically spend all day trying to kill each other. And what I liked about working with entrepreneurs and scientists is that you created things and you actually helped that to take place. And we have talked about proprietary rights, and that's creating barriers and stopping sharing. But it's creating control so you can share in the way that you want to and have the partners that you want to in business. And ultimately, when you're putting your life savings at risk and all your sweat and labor, and you're hiring people and people have dependent, you need protections so that you can build a company and build a business to make more jobs for people. So I think this has really been a fascinating topic, and I feel like I'm learning a lot in listening to everybody else on the panel and the audience, and it's been fun to participate.
I guess I'm going to talk about, say you have succeeded and the Met wants to collect your work, or some museum does, or a collector does. Be free with your information. And I say that in the sense of we are the ones preserving your legacy, so that maybe while you're alive, the copyright and patent and everything can preserve your work to a sense. We're the ones that really will be maintaining your legacy. In terms of conserving it, what's always helpful is if you can actually converse with the conservators or curators and actually state what are your wishes for this piece of art or this object if it ever had to be conserved. And so there is a push in the conservation community to conduct artist interviews where we actually delve into topics like this, that if something needs to happen, do you want us to replace it, or with what materials and in what way? And as much as possible, if that's documented, we will abide by the artist's wishes. So that's that.
So I'm going to speak as a bridge, right? So right now the landscape is technology loves solving problems. They thrive around pain points. What comes down to fashion and technology, the technology side, don't really understand the industry. They don't understand the pain points. So in the room, if you are in fashion, think about your challenges and your problems and reach out to the technology community and verbalize that to them, to not underestimate the power of that, because they don't know what you go through. And the hackathon, Rachel Roy, who was very humble about what she knew about tech, she just said, I wish someone could build an app that did X. It was something so simple. It pivoted the entire room, and the app that won was the one that solved that problem. And he solved it beautifully. If you're a tech mind in the room, do not underestimate how much you need to learn to really thrive in the fashion industry, to not be caught up by your arrogance of knowing that you know the next big thing, you have the technology mind, you're the better one. You're just different. It's a different kind of knowledge. You need the other side. So if you were to pitch a tech concept, whatever it is, to a fashion mind, learn their language and communicate. You know what? Here's a challenge. Try to say the whole story without using any jargon. In my hackathon, in the final pitching stage, they could not use the word code. They could not use the word engineer and dev. It became really hard, and it was actually quite fun to speak in plain English and in a way that it could sell an idea to a non-tech mind. So learn the other side.
So I definitely want to thank the panel. Those of you who know me, I usually do not speak that little, but this was amazing, and there's nothing that I would want to add. And the only question I have to you, and please come up to me after this, since we're doing this every month or every couple of months, I'm very interested in what the ideas would be for a panel or an event that you guys would like to see here taking place. Thank you so much for coming.